Yes, did I get that right? Okay, thumbs up, perfect. He's from there. So just to read a short bio as I introduce Arnold Mwanzu. So Arnold is a regional university librarian, East Africa at Aga Khan University, and he manages the campus libraries in Kenya, Uganda, and Tanzania, very commendable. He's currently completing his PhD in information sciences at Moore University, very distinctive. He holds a master's in information science and master's in organizational development and certificate in library at web program from the University of Antwerp in Belgium. He's a member of IFLA Environment Sustainability in Libraries, the Secretary of Kenya Library and Information Science Consortium, CLISC, the Country Coordinator of IFL, and IFLA and OCLC Fellow from the J. Jordan Fellowship in Columbus, Ohio. As you can see, he's very well decorated and distinctive. So his research interests are in library automation, knowledge management, evidence-based practice, and green libraries. He has authored 15 journal articles in peer-reviewed journals and 2 book chapters. So allow, with a round of applause, please welcome Arnold Mwanzu.
Good morning. Thank you, Florence, for that kind introduction. And I'd also like to take this opportunity to thank all the organizers of this event for involving CLISC. I know CLISC is hard to pronounce when you say Kenya Libraries Information. It's actually services, not science, services consortium. So just say CLISC. So thank you for involving CLISC in this forum. Ladies and gentlemen, as you've heard, I'll be a moderator for this session. And we'll delve right into the topic on how copyright law supports A2K and R2R. In the morning, we had a setting the scene session, but now we want to delve further. And this is going to be a very packed session with 5 speakers. So I encourage you to be alert. It's going to be interactive. So earlier on, Florence talked about acronyms, A2K, R2R. So working in a university hospital, I had to learn acronyms and abbreviations, because if you don't, you get lost in conversations. So I encourage you, join us in learning acronyms. And by the end of this session, I hope you'll have grasped at least 5 or 6 acronyms, useful acronyms. To give you a head start, I'll say happy WIPD. Happy World International Intellectual Property Day. So those who are Twitter inclined, hashtag WIPD Day. So we're going to start off with a session by Professor Sean Flynn. I'll give a brief bio about Professor Sean. Professor will be talking about the right to research and comparative copyright. Sean is the director and director of the Program on Information, Justice and Intellectual Property, American University, Washington College of Law. That's PIJIP. He chairs the Global Expert Network on Corporate User Rights and is a founding member of the Global Congress on Intellectual Property and the Public Interest. He's a principal investigator of PIJIP's project on the right to research and international copyright. He's a visiting scholar at the University of Amsterdam Institute for Information Law and a senior research associate at the University of Cape Town's IP unit. Ladies and gentlemen, help me welcome Professor Sean Flynn.
Thank you, and it's good to see so many familiar faces today and to meet so many new ones, and thank you for having me in Kenya. It's beautiful to be here. And like Melissa, I enjoy the rain. This is my favorite time to be in Nairobi, is when the rains are here. I find it funny, different Kenyans have described this as the short rains and the long rains, so I don't know if there's a clear distinction between them, but all rains are good, right? So I want to talk today a little bit about the kind of high-level global background around what we're calling the right to research on one side, and then comparative copyright exceptions on another. And I'm distinguishing those two things, and we'll describe them somewhat separately. And I think the back are going to be doing my slides, so instead of telling them, I'm just going to like raise my finger. Does that work? And then you can go to the next one. Yeah? Now, when I do that, I want you to go to my next slide. They're all waving their fingers back. Okay, there we go. Okay. So the reason we use human rights, laws, rules, and discourse is to give us a tool to challenge inequalities, right? That's one of the primary uses of human rights within the legal frame. So we say all laws, all rules, all parts of what government does to regulate society must comply with these universal human rights, which are supposed to be transformative in some way. It's supposed to give us a vehicle to challenge rules and structures and operations that disadvantage us. And so in this access, in this realm of access to research, we are living in a world of radical inequalities. So this is a chart taken from a recent book that was published in India. And they were trying to talk about what kind of copyright rules should dictate whether we can share our works digitally. And they said, you must look at our Indian libraries versus, for instance, a United States library. And you can see from this chart, for instance, that a middle-tier law school, like the University of Maryland Law School, it's a perfectly fine law school. Most of you have probably never heard of it. It's kind of in the middle of the groups of law schools in the United States. Has about 10 times as many books per capita than the best law school in India, than the very top one, than the Harvard Law School of India. Then if you compare that Harvard Law School of India with the Harvard Law School of the United States, you have like 100 times as many books in that library in the United States. So we're living in this world. I don't have the figures on Africa, but I'll bet they're even lower. You know, our libraries here are going to have even fewer resources. So one of the solutions, of course, is, well, our governments must buy more books. But another solution is to look at the different laws that regulate how we access and use those materials. So we turn to human rights. What does human rights have to say about these things? So we've been calling and kind of conceptualizing what we're calling a right to research, but you won't find a right to research in those terms in the Universal Declaration of Human Rights. But you will find in Article 19 the right to freedom of expression, which includes the right to receive and impart information in whatever form. And isn't that what researchers do? And you will find in that Universal Declaration the right to education, which is another vehicle for receiving and impart information. We heard from teachers this morning. And you will find in that Universal Declaration the right to share in scientific advancement and to benefit from culture. And isn't that also a right to receive and impart information? And all of those rights must also be balanced to a right in Article 27(2) to the protection of the moral and material interests of authors. So authors themselves have rights. We have rights to benefit from our creations. And often we think of that as part of the motivation for creating copyright laws. But those copyright laws must also be balanced within these other rights of society. So as part of our project, we've been producing content, producing articles, including one of them written by an African researcher, teasing out the implications of those different rights within our national and international and regional human rights systems. And the key kind of juristic component of human rights is that human rights create duties on the part of the state, right? And so those duties can be classified into three aspects. So the first is what we sometimes call the negative right. It's the duty to respect, which means the government itself, in its positive action, when it passes laws, like copyright law, when it passes regulations, like your data law, your artificial intelligence laws, etc., it must respect those human rights that I've talked about. So it must not negatively affect them. And if it does, then you go down to justification, then it has to have a compelling interest, and it has to narrowly tailor, and has to be not more onerous than necessary. It also must protect, it must regulate third parties, and then it must positively fulfill. It has to take affirmative steps to promote each of those rights. So you can see within that concept the positive effort to create libraries, for instance, helps promote the freedom of expression, the right to receive information. But that's not just a duty to refrain from acting, that's a duty to positively act, to create institutions, to create libraries and archives and museums, educational institutions, universities, to pay teachers. All of these require positive efforts by government to promote what we can call the right to research. So we take those human rights and we keep them in mind. And now we say, what is copyright? Copyright is itself a positive intervention. Without copyright, you can exchange any information freely, right? Copyright comes in, we heard this morning, and says, no, that author, that rights holder can prevent you from accessing or sharing that information under certain circumstances. And if it only said that, if it had no what we call limitations and exceptions, we can call them user rights, rights to use copyrighted material for different means. If you didn't have them, then our argument would be your copyright law would violate those human rights principles, right? Can you actually say that each author can prevent everyone from reading their work without their permission, from quoting their work without their permission, from learning from that work, from teaching that work without their permission? And the law historically, here quoting from the first copyright treaty from the 1880s, has always says, no, there have to be exceptions to promote the public interests within that copyright framework. And the first exceptions that were mentioned in 1886 is for education and research. Those are some of the primary means that we have to allow uses of copyright material, to teach and to learn. So I'm not going to give you the entire historical history, but I'm happy to give you some citations where we give some of it. But speeding ahead, we've been using that concept, using the human rights concept on one side, using it to develop a notion that there must be proper exceptions for research within copyright laws, and then analyzing laws around the world to see, do they match up? Do the laws have adequate exceptions for the kinds of research uses that we need today in the digital environment? So when you looked back in that 1886, the only exceptions for publications in scientific and educational books and publications, right? You know, thinking about the printing press. But now we're on the internet. So now we need digital rights within our research and education. Right? Does your exception for education say you may only use a material in a classroom? Does your research exception only say that you can quote it in a research publication? If those things are true, then you can't do the Masahane project. You can't create language translation tools. You can't engage in text and data mining where we create huge corpuses of materials and use machines to learn from them. So this is a map of the world that tries to answer that question. You can see the key on the bottom. This is the one published in Science magazine this year. And the colors might be a little hard to make out, but the US and Canada, that color is supposed to be green. I'll refer to that as green. And in those countries, in the green countries, So first of all, in all countries, there's a research exception. Every country has a research exception. But only in the green countries is that research exception applicable to all kinds of works. So does your research exception only apply to books, or does it apply to movies and music and everything else, right? All kinds of users. Do you have to be a member of a library or a university in order to benefit from the exception, or can you be anyone? Can you be a person? And then all kinds of uses. So copyright, as we learned this morning, on the one side protects that right to copy, but then it also actually protects the right to communicate those copies, including on the internet, to make it available to others, to display it. There's all these different kinds of uses. And so sometimes what you find is the exception only applies to some uses and not other uses. So the green countries have what we call an open research exception, and in those countries, you at least have the right on the face of the exception to make an argument that these new uses are incorporated, that you can make a copy of a whole work through a digital format for the purpose of a text and data mining research project. That the exception is open enough to enable that kind of an argument. In the other countries, there's some kinds of restrictions. So in those dark blue countries, only some kinds of works are subject to the exception. In the kind of yellowish orange country, only some kinds of users may make use of that exception. And in the red countries is the biggest problem. They only have a right to quotation. The only research use you can use is that one from 1886, the right to quote a work in a research publication. Now, you may have spotted Kenya in our map. I'm sure you all were noticing which one that is, because you can see your own country. And we actually rate Kenya as a green country, because Kenya has a fair dealing exception. People have been saying fair use, fair dealing, and I think fair use and fair dealing are the same. The word dealing and the word use mean the same thing. So fair use, fair dealing, those two words mean the same thing. The difference is that in many countries that call it fair dealing, and it's true in the UK itself, which still uses that term fair dealing, you can use a fair dealing only for a certain number of purposes. And you see that's true here. The doing of any act, so that I said, reproduction, communication, whatever, any act, covers any act, that's good. By way of a fair dealing, so that just means the act must be fair. It must be fair to the author. You must not be taking away a market of the author. You can't make that copy and sell it on the street, etc., right? That would be piracy. For the purposes of. So in the US, it says for purposes such as. That's the only difference. Such as or of. So by saying the purposes of, these are the only purposes that you can make a fair use of in Kenya currently. Whereas the US, it says purposes such as. So the courts over time have said, well, we'll look at other things, and such as essentially means any use that's fair, any use that doesn't substitute in the market, any use that's not piracy. Really, no matter what the purpose is. And that's given the court's flexibility to say certain kinds of digital uses, like digital video recorders, cloud storage, things like that, those are fair use as well. But for our purposes, for research, the important thing is to say acts by way of fair dealing for purposes of scientific research. So I would say that's actually broad enough to encompass most of the research issues that we're talking about. And I think Melissa this morning said, well, it could be more clear, and I agree. So other laws have actually said, including text and data mining, or including computational uses, or including uses in the digital environment, or whatever. So there are ways the law could be more clear, but you're actually in an environment where I would say one of the things you could be doing is making use, and spreading information about the flexibilities that are already there. And so there's a couple things, and some of these issues have already arisen today, where your own copyright law could be improved. And we've written a memo on some of these issues already. But so one is, what do we mean by scientific research? I mean, in the international literature, that word scientific is actually very broad. We don't mean only biology and chemistry or whatever. We basically mean the quest for knowledge. But one could maybe define that. So in the United States, for instance, we don't say scientific research. It just says research. It's a more general term. This term scientific research is old. It comes out of very old copyright laws, and it's not the way we use the terms today. So one could clear that up. One could define research to expressly include text and data mining, computational research, etc. Contracts. Remember the story today? The Jehovah's Witness attached some contract onto their data set and said, well, you can use it, but you can't use it for text and data mining. Well, so now, even though your law says you can, the license says you can't, who wins? And it's not clear under the current Kenya Act. But some laws around the country have made that clear. They've said, no, if it's a user right, you can't override it by contract. So we don't care what the Jehovah's Witness puts on their webpage. You can use it because the copyright law says you can use it. So that could be clarified. And then finally, one could shift a little more towards the US environment and include that word such as to open those purposes to be more flexible over time. So these are some of the issues that we're happy to talk about further and that may come up, including in this panel. But for my context, I'll leave it there. And thank you to the guys in the back. It worked well. Cheers.
Another round of applause for Sean. So thank you, Sean. I think that was a wonderful, insightful global perspective of R2R. For me, I've learned about how Kenya ranks in terms of exceptions. Yeah, to know that Kenya is a green country. How many have learned that today? Yeah, great. So we are getting there. So that was something good, learning from the global perspective. And I think to delve further into that, we are going to welcome the next speaker, who is Jonathan Band, an expert at policy bandwidth. I'll give you a brief bio about Jonathan. So Jonathan helps shape the law governing intellectual property and internet through a combination of legislative and appellate advocacy. He has represented clients with respect to the drafting of federal and state statutes relating to intellectual property and the internet. Mr. Ban has also represented clients in connection to the Marrakesh Treaty and other international agreements. I'm sure most of us are familiar with the Marrakesh Treaty. He is an adjunct professor at Georgetown University Law Center and has written extensively on intellectual property and the internet, including books, Interfaces on Trial, Interfaces on Trial 2.0, Interfaces on Trial 3.0, and over 100 articles. In 2017, he received the American Library Association, ALA. That's another abbreviation, yeah? ALA Ray Patterson Copyright Award, which recognizes an individual who has supported the constitutional purpose of the copyright law, fair use, and public domain. So Jonathan is going to talk about do licenses help or hinder the right to research? He's going to give us new global findings. Let's welcome Jonathan.
Thank you very much. I'm very happy to be here. If we can have my slides put up. So one of the things, I didn't realize that one of the themes of the World Intellectual Property Day this year is women in IP. And the whole first session I was trying to think, how do I connect my presentation to women in IP? And I haven't been able to come up with it. I mean, my wife is a woman, my daughter's a woman, but I think that's as far as it gets. In any event, maybe you all will be able to come up with a more clear connection between women and IP and my presentation. Next, please. So this presentation really builds off of a point that Sean made when he was talking about contracts and protecting the exceptions from contract override. So now in the digital era, we're getting more and more content subject to licenses, and that's a good thing, right? Because the licenses, we have access to more content than we ever did before. But unfortunately, the licenses often include terms that purport to limit the copyright exceptions, and the Jehovah's Witness example from before is a perfect example of that. But you just think of almost any license, whether it's an Apple iTunes license or Netflix or any content when a library participates in a consortium, there's always licenses, and the license terms contain provisions that typically limit what you can do with that work that you're licensing. Now, since 1991, no, not yet, go back please. Since 1991, the EU directives related to copyright have contained clauses that require the nullification of license terms that are overriding specific exceptions that are mandated by those directions. Basically, the policy is what I say in this last bullet point. In the EU, they sort of recognize what is the point of granting an exception if a licensor can simply unilaterally override it, right? If the licensor has the ability to just say, forget about that exception, you can sort of say, well, why should the legislature, what's the point of the legislature spending all this time coming up with those exceptions, especially in an environment like the digital environment where more and more of our content is licensed. And this is, again, when you think about a library, libraries in the United States now, large research libraries, 80% of their acquisition budget is spent on licenses. So they're licensing far more than they're buying in terms of, they're licensing electronic content much more than they're buying physical content. And if you just think about you yourself personally in terms of how you're getting content now as opposed to 10 years ago, as opposed to 20 years ago, right? In all of our lives, we're getting more and more of our content digitally subject to licenses that are often limiting those exceptions. Now, please. So these are the 4 directives that the European Union has adopted that include what I call contract override prevention clauses. We can call them COP clauses for another acronym. I think I'll just stick to, in this context, to override clauses. So these are the 4 directives have these override clauses. The software directive was the first one back in 1991, so we're talking about over 30 years ago, where they said if you were making the directive allows an exception for making backup copies and also reverse engineering. And then they said, and you can't override that by contract. Any contract term that tries to override those exceptions is null and void. It's just not enforceable. Okay, so they already did this more than 30 years ago. And of course that's related to research, right? Because reverse engineering is a form of research. The database directive contains an exception that says the use of an insubstantial part of a directive is not, the use of an insubstantial part of a directive does not violate the database directive, and you can't override that by contract. The Marrakesh directive also has one of these clauses, and it basically says you can't, the whole purpose of the directive is to require countries to adopt exceptions for people with print disabilities to make accessible format copies and distribute them. And again, you can't limit that by license in the European Union. And then the most recent, the Copyright and the Digital Single Market Directive, there are exceptions for text and data mining, online education, and preservation. These are by educational institutions and cultural heritage institutions. And again, the directive says that any contract term that tries to override one of those exceptions is not enforceable. And so this then needs to be implemented in national law in all the countries of the European Union. Next, please. So now we're going to start seeing some charts of countries. So now I'm listening, these are the countries with targeted override clauses. So we first have all the EU member states. So again, every EU member state needs to have those clauses preventing override of the exceptions of the categories of exceptions I just previously showed. So those relating to the Software Directive, Database Directive, Marrakesh Directive, and Digital Single Market Directive. So they all have, those countries have all of those override clauses. Now, the countries seeking EU membership, and that's the list on the right, they also either have already adopted those clauses or will adopt those clauses, because to become part of the European Union, they need to adopt those laws. So they all already have those exceptions with respect to, those clauses with respect to the Software Directive, because it's so old, it's from 1991. So all those countries have had a chance to adopt those clauses, but they haven't yet adopted all the others. Next slide, please. And here's more countries that have those clauses. The European Free Trade Agreement members have, typically, these countries have the clauses related to the Software Directive. They haven't necessarily, they don't have to adopt the other ones. It's up to every country, and that's under discussion. And then others outside of Europe, you have Australia and New Zealand. They both have the Software Directives clauses. Greenland, because Greenland has a strange status relative to Denmark, so Greenland has it. Interestingly, Malawi has a clause relating to the Software Directive or its software exception. That probably is the outcome of negotiations with the European Union. And then finally, Russia has something that looks like an override clause in connection to software. And I think that this was adopted in the late 90s when Russia was trying to be a little closer to the European Union, and so it made a lot of amendments to its laws to look a little bit like the European Union. Less interested in that, obviously, these days. Next slide, please. Now, everything we've been seeing are sort of very targeted. Where the countries have just adopted these override clauses with respect to a very limited number of exceptions. However, these 13 countries have decided to adopt override clauses with a much wider range of exceptions. Some of them do it for all exceptions. Others do it for most exceptions. What's interesting about this list is there is no pattern here, right? Whereas the earlier stuff, we could see it was very European-centric, right? Because you started with the directives, and then you had had all the EU member states, and then you had the countries that wanted to be members of the EU, and you had the European Free Trade Agreement clauses. Okay, so there was a very definite European focus to it. You have some countries that are within the EU that went much further. So Belgium, Germany, Ireland, and the UK, when it was a member of the EU, after Brexit, it continued to keep its very broad exceptions. Portugal, right? So all that makes, okay, you could say, well, they thought the idea of preventing override was such a good idea that they would expand it to all their exceptions. But then you have Cook Islands. Why the Cook Islands? I don't know. Kuwait, and then most recently, and then Singapore. And Singapore is an interesting case because those of you who know anything about copyright law, Singapore has like the most complicated copyright law known to mankind. They don't want to leave anything to any ambiguity, right? They specify everything in excruciating detail. And whereas every other country, their override clause is pretty simple. It basically says, you cannot override this exception, let's say the exception in section 26, you cannot override it by contract. So it's just a simple clause, one sentence, nothing more. In Singapore, it's like 5 pages long, and it has all kinds of provisos, and it depends on the kind of contract, whether it's negotiated or non-negotiated. It's extremely complicated, but it's very thoughtful. I mean, they obviously spend a huge amount of time to figuring out what they thought was the appropriate way to handle this issue. But of perhaps greatest interest to this audience is the most recent country to adopt an override clause is Nigeria. Nigeria just finished an overhaul of its copyright law that the president just signed into law, and Nigeria has a general override clause. Basically, it says that you cannot override any of its exceptions by contract. Any contract that tries to override an exception is null and void. Now, South Africa's new copyright amendment bill also has the same kind of general override clause, but of course, as you probably know, that still is not law, right? It's passed Parliament, but it's a whole long and very sad story. We're not going to go into it, but the point is that the Parliament had it, but it has not yet been signed into law. But in Nigeria, Parliament passed it, and then it was signed into law. Next slide, please. So here, because Sean had maps, I thought I needed to have maps too. What you'll see is that it's much more concentrated. So the targeted exceptions, those are the ones where you have override clauses for just a few exceptions. You can see it's all very European-centric, plus Australia and New Zealand. You have Russia, which obviously is a very big country, but it's but if you didn't have Russia, you'd really have this very concentrated area. The general is even smaller. You can barely make it out. It's the blue countries, the light blue countries, and so again, mainly in the UK, mainly in Europe, but you also have Nigeria, and then Singapore, and a couple of other places, spots around the world. Next slide, please. This focuses also just really, much more on the situation, how it's really, this whole approach is very Europe-centric, but as we've said, it's starting to expand beyond Europe into Singapore, Nigeria, and so forth. So that's it for my presentation, but I'm going to give you the takeaway so that when you're asked what the takeaway is, that you focus on this presentation and this. And the point is that Kenya should adopt a clause that overrides contracts that attempt to limit exceptions. That's the key takeaway. You should do what's been done in like in the UK and Nigeria, that South Africa's trying to do in Singapore and so forth, and have a general clause that prevents the overriding of exceptions. Thank you.
Thank you, Jonathan. Can we clap until he gets to his seat? Thank you. So that was another insightful and distinctive global overview of R2R. So now we've got the global perspective. And I think for me, I learned the targeted contract override prevention clauses. Sadly, Kenya doesn't rank so well in the map. So I hope the next speakers who are coming from Kenya will tell us what they're doing or what we can do to get on that map. So this was interesting for me as actually my master's thesis was on digital rights management, DRM. So for me, that was a lot of insight in some of the new findings, milestones since that time. So now our next speaker has actually been here before as a moderator, but now let me also introduce her, because that time she was introduced as a moderator. I should introduce her as a speaker. To give us a local perspective is Chebet Koros, who is a research fellow at Intellectual Property and Innovation, CIPIT. And she'll be talking about R2R and TDM. So Chebet she leads the research on the intersection of IP law and innovation at the CIPIT in Kenya. Through her work, she aims to influence Kenyan IP policies as well as inform IP policy change within the region and globally. Her current research focuses on the role of Kenya's copyright law in enabling text and data mining research. She also researches the IP issues involved in artificial intelligence and has co-authored a handbook on copyright protection in Kenya for creatives and IP practitioners. So, ladies and gentlemen, if you've never heard about ChatGPT, probably Koros will tell us. Let's welcome her.
Good afternoon and hello again. Unfortunately, I will not be presenting on ChatGPT. I will be presenting on our policy brief, which if you're in the room, you should have a copy in your pack. And if you're on the webinar, we shall share a link to the soft copy in the chat. So I'll welcome you to have a look at it, and I will present and give you a highlight on what it is. So as we wait for my slides to come up, yes. So that is the same image that you see in your hand or on soft copy. So CIPIT has been carrying out a study to determine the relationship between Kenya's technology and copyright legal framework that affects the use of TDM research. And my presentation today is just to give you a highlight of this policy brief, although I invite you to have a look in depth later on. So my presentation will have the following outline. I'll take you through an introduction where I give you the purpose and objective of our study. I'll also take you through our methodology, where I present the methods that we employed in the research underlying this policy brief. And I'll give you a highlight of our key findings, and finally the policy recommendations that we propose to enable text and data mining research in Kenya. So I'll begin by giving some definitions. I'm sure the other presenters and speakers have given you various definitions, but I'll still go through it quickly. So first of all, what is copyright? Copyright is an intellectual property right that protects an owner's original literary, which is written work, or artistic work. Under the Kenyan law, an example of copyrighted work is a compilation of data, which is essential to my discussion and to our policy brief. So copyright gives the owner the exclusive right to copy, translate, distribute, and publish their work. And a person who is interested in using work that is copyrighted often has to ask for permission from the copyright owner and pay for it. However, there has to be a balance between the copyright owner and the copyright user. That's where the exceptions and limitations come in. And in our copyright law, this is found in section 26. The use of exceptions is known as fair dealing in Kenya, as has been explained by Sean before and Natasha. And it allows certain purposes to be used without asking for permission. So one of this is scientific research, which is the core of this presentation. The right to research can be defined as the right to conduct and receive or access research, which is justified in our Constitution under Article 33, which provides for the right to freedom of expression, and this includes artistic creativity, academic freedom, and freedom of scientific research. And lastly, text and data mining can be defined as using software to analyze a large amount of digital information to find patterns and relationships. And TDM is often used in various fields to answer research questions and to generate new hypotheses. So why is it necessary to create a legal environment that supports text and data mining research in Kenya? One thing is that researchers require digital tools like TDM and access to data to contribute to human knowledge. I'll give you the example of a TDM project named Blue.ai, which led to the discovery of the coronavirus outbreak well before WHO had announced it. So in December 30th, 2019, the AI platform was able to pick up a cluster of unusual pneumonia cases around the market in Wuhan, and this advanced vaccine research. Another reason is that the TDM process involves 4 steps where you identify the relevant document, you convert this to machine-readable format, extract structured data, and mine for new knowledge. So while you're doing this computational analysis, most likely you're going to end up having to reproduce copyrighted or copyright-protected work, and this can be from scanning the copies of analog works, formatting the texts and data, preparing them for processing, extracting useful information, all up until you store the data that has been mined. So the TDM process often requires reproducing copyrighted works, and it means that copyright can be seen as a barrier to TDM research and to access the necessary data. So the law that the law must create an enabling environment for TDM researchers for them to be able to operate. So that brought us to our research objective, which was to determine how Kenya's technology and copyright legal framework affect the use of TDM and to make recommendations that enable text and data mining. So the research that underpins the policy brief that I'm presenting on employed 3 interrelated methods. Firstly, we had a legal review where we analyzed Kenya's tech legal framework that promotes learning, research, and technology growth. Among the laws that we had analyzed, including the Constitution, was the Science, Technology, and Innovation Act, the Computer Misuse and Cybercrimes Act, the Data Protection Act, the National ICT Policy, and the Distributed Ledgers and Artificial Intelligence Task Force report. We also made a comparative analysis between Kenya and South Africa's copyright law in terms of the exception for research, and we looked at the relevant provisions of their constitutions, that's the Kenyan and the South African constitution, as well as the copyright laws and case law. And finally, we had a brief survey where we conducted a questionnaire among TDM users and developers to assess the practical impact of technology and copyright law on TDM developers and users. So moving to our key findings, we had 3 main key findings. First, we found that Kenya's technology law, laws and policies has the potential to promote research and technology. However, there's a caveat: if these laws are implemented and are updated. So Kenya's technology legal framework, we saw that it's adapting to shift towards the digital economy and prioritizes research and development. And the government has demonstrated its commitment to this goal through various policies and strategies that are designed to support tech and research initiatives. This supports the environment, and it's likely to encourage innovation and progress in the technology sector and in the field of TDM. So among the laws that we looked at was, to start us off as a foundation, was the Constitution. So Article 33 of the Constitution guarantees academic freedom and freedom of scientific research, which lays a foundation to promote research in Kenya. Then we looked at the Science, Technology and Innovation Act, and through its commission, known as NACOSTI, it aims to promote technological advancement, education and research in Kenya. And the Data Protection Act under Section 53 also promotes research by acknowledging that if collection of data is for research purposes, then further processing of personal information is compatible with the purpose of data collection. There's, however, a need in the Data Protection Act under this section for the Data Commissioner to enact a code of practice for processing personal data used for research. Then we looked at the National ICT Policy and Guidelines, and we found that they do seek to promote science, technology, and innovation. And they create an ecosystem that is self-sustaining and produces excellent research, technology, products, and industries. There's a report by a task force. This is the Blockchain and AI Task Force report. which was published in 2019. And this is a key report because it shows us how the government seeks to tap the potential use of emerging technology, such as AI, where TDM would be falling under, to the maximum benefit of Kenyans. We also found that though most of these laws do promote or seek to promote research and technology, they do not apply to the current digital world that we're living in. And so they need to be updated to promote learning, technology, the use of TDM, and other modern research methods. Another common gap we found in these laws is that they do not have proper implementation strategies. And so we have great laws, we have great policies, we have great strategies, but they've not yet been implemented. Our second key finding was that the Kenyan copyright framework could permit text and data mining research. As Sean had presented on before, we are in the green. So that means that our law is pretty open. However, this law needs to be interpreted appropriately, guidelines need to be made, and also it needs to be updated. So we came up with several considerations that in amending our law, our copyright law, the lawmakers can consider. So in our research, we also looked at South Africa, and we chose South Africa to compare their law because similar to Kenya, the current South African law provides for the exception to research. However, as has been mentioned before, South Africa has a copyright amendment bill which seeks to move towards the fair use format rather than the fair dealing. So in comparison to fair dealing, fair use has guiding factors that help to determine whether a certain use is fair or not. And as one of the speakers before had talked about a case, that is the Communications Commission of Kenya and 5 others case, where the Supreme Court relied on a 6-factor test to determine what is fair. So can TDM use this test? It's out for debate. I'll just mention the factors once again to consider when determining what is fair. So one, you have to look at the purpose of dealing, the character of the dealing, the amount of the dealing, alternatives to the dealing, the nature of the work, and the effect of dealing on the work. While there is no clear understanding whether TDM research amounts to scientific research or research in Kenyan and South African law, a TDM researcher can employ this 6-factor test to determine whether the use is indeed fair. Given this confusion, is there really an alternative? In South Africa, we've seen that possibly to cure this ambiguity, there's a move to amend the law, and under Section 12A of the Copyright Amendment Bill, they seek to shift towards the fair use exception, and this would provide a future-proof law that would enable modern research technologies like TDM. We also found that there are some countries, as have been mentioned before, that already have a specific exception for TDM, and this is Singapore and Japan. And this clearly enables TDM researchers in these specific countries to be able to use it without having any ambiguity or are they here, are they there. And then lastly, we had a survey of TDM developers and users, and this was to identify their awareness of Kenya's copyright law in enabling TDM research. So our key finding here was that most of the TDM developers and users surveyed were unaware of the fair dealing copyright exception. However, they believed that copyright is essential for TDM research, and only 18% were able to identify the Copyright Act as promoting technology, learning, and research. So it was also crucial for our study to find out whether the respondents were aware of copyright exceptions and limitations that allow for copyright works to be used for specific purposes without a license. Here we found that only 18%, yes, as we can see, only 18% of the respondents had used the fair dealing exception, which means that they were also not, they were aware of this, while the majority of the respondents were not aware of this fair dealing exception or had never used it before. Interestingly, we had one respondent who said that this exception, the copyright exception for research, does not apply to the use of text and data mining for research purposes because processing of data requires approvals and licensing, hence limits research. However, we found that most respondents who believe that copyright law, we found that most of our respondents believe that copyright law affects text and data mining research, machine learning, and AI in Kenya. And some of their explanations for this was that copyright provides protection on generated works aided by AI. Then others found that copyright causes limitations to innovation, and others found that copyright hinders the abuse of protected data. We also sought the opinion of the respondents as to the importance of having a defense to copyright infringement for TDM. And majority of the respondents believe that it was very important to have the TDM exception for research, while very few said that it was not important to have exceptions as shown. If we can move on to the next slide. So we can see the difference between those who found that there's a need for this and others who did not. So those who support the exception had this to say. The research is used for further insights and shows gaps in knowledge, that works of public good do not require limitations. Another thought that it's not easy to get funding for some types of research, and thus this exception would help get required data for research. That there have been less TDM development due to the bureaucracy copyright law sometimes imposes. And then for those who thought that copyright was not important, it was because that they believed that it would give room to unfair use or abuse of data that the owner was heavily invested in generating. So with all of that, we come to our policy recommendations, which I will go through quickly. However, I invite you to look at them more in depth in the policy brief. So we have one of our recommendations is that the Kenyan government ought to enforce existing technology laws and policies that promote research. And this requires creation of new laws. It requires modifying the existing laws, and it also requires engaging the policy in the decision-making process, or what we call stakeholder engagement. Secondly, we see that the Kenyan government should reform outdated technology laws and policies to promote research and technology. And there are very many wonderful proposals on how AI and emerging technology and TDM can be used for the benefit of Kenyans. And the government has also provided that through the 2019 report. And one of our recommendations is that we adopt the policy and regulatory framework proposal that is within that report. Then third, we say that the Kenyan government should establish clear guidelines and strategies that provide access and use of data for research purposes, such as TDM. The Kenyan government should also provide financial support for research, for the development of high-speed internet, and to broadband infrastructure. We also propose that there is access to data repositories, free access that is available. Then on our fifth recommendation, we say that there is need for promotion of collaboration among government, researchers, industry stakeholders to facilitate the exchange of ideas to the development of technology. My time is sadly up, but I will mention the last few. So I have mentioned before on the copyright reform that we recommend, and as you can see from the slides, clearly we have proposed a couple of amendments. One is to expand the existing narrow fair dealing framework. One is to shift to the fair dealing or fair use, as South Africa is doing. And in this one, we say that under Section 26, if we can add the word such as, we'll be able to have a much broader law. And then if we can have the definition of fair scientific research in the law, that will help in ensuring that there is no ambiguity in what exactly am I doing that is fair, or what is scientific research. And then we also see that, if possible, we can have a specific exception for research. And then we have one of the issues that we saw with the survey was that there's a lack of awareness. So we recommend that Kekobo assists in giving out guidelines on how the existing exception that we have as is can be applied to digital research such as text and data mining. And then we also seek that the government should promote increased awareness and education for copyright exceptions. We have two more, but then I think we'll leave it at that. maybe we can just show, there we have in the slide. One of the things is we have teachers in the room, we have librarians, and one of the discussions I was having with someone at the break is that careers have changed in the digital age, but are the students who have not yet started their careers, are they being taught in their curriculum how to incorporate the digital age in what they're learning? So we propose that that should be added in the curriculum. Thank you very much. I welcome you to access our policy brief, engage with it further on the soft copy. Thank you.
Wow, thank you very much, Chebet. That was a great local perspective of how Kenya's legal framework on technology has the potential to cover TDM, only if it's well implemented. How many of us, because from the research she said 82% don't know about the fair dealing. So I just want to know in this room, how many of us are familiar with the copyright fair dealing provision? Or rather, have you applied it? Anyone? In Kenya? Oh, so your 82% is here, Chebet. Right, so now we move to the next, presentation, which is going to be perspectives from the classroom. And to take us through this session is none other than Dr. Catherine Nandain, who is a lecturer at the Technical University of Kenya. She's an experienced educator and researcher with a PhD in public administration and a Master of Arts in Communication. She's currently a lecturer at the TUK, where she teaches and conducts research in the Faculty of Social Sciences and Technology, School of Information and Social Studies, Department of Government and Legal Studies. She has also published several articles on policy analysis and education reforms in various academic journals and conferences. So Dr. Nandain is going to talk about education and copyright. And just like Chebet, she'll be giving us findings, interim results for research commissioned by Education International. Let's welcome Dr. Catherine Nandain.
Good morning. Yeah, mine is not a global perspective. Mine is a Kenyan classroom perspective. My name is Catherine Nandain, like I've been told. And I was doing this research in collaboration with Charles Nandain, who is in the house. He's the copyright person. I'm the educationist in this case. And so I'll go straight to our research. And this research was commissioned, if we can move, it was commissioned by Education International, which is, just tap again. It is a federation of unions representing over 30 million teachers and education workers across the world. Now, so the purpose of Education International commissioning this research is mainly to respond to questions of increased privatization as well as commercialization of education, where you must pay so much for you to be able to access teaching and learning materials. Let's move on. So this study was part of the study that is being conducted in Africa, and the two countries in Africa are Kenya and Senegal, and therefore we had the pleasure to be the Kenyan team. And so, let's move. So the main aim of this study is to establish equitable access to teaching and learning research materials. And what is the main question? The main question is, how does copyright law in Kenya affect access to teaching and learning materials in the classroom? And so we wanted to hear from the teachers what they have to say about their experiences. Let's move. So the general objective was to gather teachers' perspectives of the access and use of teaching and learning materials in light of copyright laws in Kenya. Our specific objectives: one was to determine the teaching and learning materials used in the classrooms. Number two, to establish the strategies that were used by teachers in accessing and using teaching and learning materials. Number three, to assess the teachers' knowledge and awareness of copyright laws. And number four, to determine the challenges the teachers encountered from a copyright perspective. And number five, to determine how the teachers attempted to overcome these challenges. And so we were looking at the teachers at 3 levels: the basic education, that is the primary level. We were also looking at the teachers and the secondary school teachers, as well as the university level. And at this point, I would like to bring to our notice that we really relied much on the teachers' union, or the leaders of the 3 unions, that is NAT, and we have a member who was very key in this research, who helped us to coordinate this research, and that is Jedida. Is Jedida in the house? Please just raise your hand. Jedida is there. We also have a representative from KUPPET. This is the union for the teachers at the secondary level, and we have a representative in the house. Kindly carry up your hand. Thank you. And then we have WASU chair, that is the national chair. Madam Grace was here, and so she was also part of the team. And so the way we landed on the teachers, the specific respondents, is that we got these leaders to identify for us specific teachers at their level, but with the purposive ideas at the back of our minds, so that we could have inclusivity and representation. And especially we were keen to ensure that we have teachers from both the rural and urban setting, and then we also have teachers who either themselves have special needs or they deal with children with special needs. And so with that, we were able to get, we had 2 tools. The tools that we used for data collection were 2. Please, let's move. Okay, before I talk about the design, we had 2 tools. We had a survey, which we used for the university, basically. Mainly we used for the university, although we also have some teachers at the basic and the secondary level that we gave the survey, especially when they missed out on the focus group. And so our second tool was focus group discussions. And so we had a focus group guide, which we used with the teachers at the basic level, and especially for those with the special needs. And therefore, all our research, the 2 tools were used online. The survey was used through a Google form that we shared with the members, union leaders. And then for the focus group discussion, we had the members, we had Jedida actually coordinate teachers across the country and put them together, and we scheduled 5 focus groups. So let's move. So our research design is we adopted a mixed methods design with a convergent parallel design as the methodology. Now in this method, what happens is you collect data separately, and so we have the results of the data for the survey, and then we had the data from the focus groups. So you analyze them separately and then compare them for either divergency, convergency, or otherwise. So let's proceed. And so we did some literature review of both Section 26 of the Copyright Law of Kenya and other empirical literature. And I would like to request from here that I will not go through the literature. This one you can read for yourself. And so we move to slide 12. To the findings. Slide 12, please. 13? Yes, the findings. So these are the findings from our research. And so, like you'll see, so this is about materials used by teachers in schools. 50% indicated that they used the listed materials. And here, these materials are either books or published books, reference books, or other published works. 25% used them every day. The 50% used the materials almost every day. 25% used them every day. 17.5 said sometimes they use them, and 1.5 and never, never and almost never, also 1.3%. That is for the survey. And so let's move to the next slide. That table is from the focus groups. And so from the table, these are the materials that the teachers said they used from the focus groups. And so you can see that the chart had 9, the frequency is 9, books are 5, pictures are 3, as you can see in the table. Now, these items with the highest frequency are actually copyrighted materials. Next. Now, we discussed the surveys. We had to look at the survey vis-a-vis the focus groups, like I told you, in the method that we used. And so both of them have a convergence that actually teachers at all levels used the materials, the print materials that were mentioned. Now, this has a copyright implication. Let's move. Strategies that were used by teachers to access materials. So this was served by question 6, and the respondents were required to write or to indicate in their own words what they did if they did not have access to teaching and learning materials in accessible format. So the figure there shows what the teachers wrote. This is in the survey. And so we were able to compute their responses, and therefore the findings are as shown, that 20% improvised when they did not have materials, 13.8 said it was not applicable, the question was not applicable to them, 13.8 said not applicable, while the rest had their own varied responses, but in very negligible percentages. Let's move. So this is the qualitative responses. And so from the focus groups, this is what the teachers said. They indicated that teachers used various strategies, again, to gain access to materials. Again, improvisation stands out in the focus group. And these are some of the quotes by the teachers. And so, for example, one of them says, we got materials from the environment, which also suggests that they improvise. We take lollipop sticks or biro tubes, and then they have the children do some beadwork. That again is improvisation. And then others also repeatedly said, we can improvise. We improvise from local materials. So improvisation again stands out. Let's move. Now, so looking at both of them, that we see that both the qualitative and quantitative data are converging on the strategies used by teachers to access teaching and learning materials. Now, as to whether what they actually use are actually used with respect to fair dealing or fair use is subject for further research. So let's proceed. Knowledge of copyright. So we asked the teachers whether they had any knowledge. It was just a basic question of, do you know anything, or what do you know about copyright? Now, from the surveys, this is now, remember this is at the university level, yeah? So the respondents stated that I am somehow familiar. This was 47%, followed by I am familiar, 13.8%. I am very familiar was the lowest, 1.3. Let's move. So these are some of the statements now we got from the focus groups. When we asked the teachers at that level what they knew about copyright, most of them said, this is when someone tends to reproduce somebody else's work without acknowledgement. Then another one says, reproduction of material that was produced by someone else. And then, I don't know the laws, but sometimes when you are in the website, you want to get some images, then which is too difficult to get them off. There's some message that blocks them. Now another person says, I have no idea. And others. Let's move. So in our discussion, we say that the findings are in the two sets of data again are converging. So it's apparent that the teachers have some idea of copyright laws, although they may not be very conversant with the details, especially when we talk about fair use and fair dealing. They know there's something, but they cannot tell you much about it. Let's move. The challenges related to copyright. So from the survey, these are some of the challenges, and that figure shows us the challenges, that 36.3% experience some uncertainty, not knowing what to do, 30.0% limited permission, and then prohibitive costs also stood at 18.8. Now, not applicable, 1.3, while the others were at negligible percentages. So the figure there represents the challenges. Let's move. Now, this is from the focus group discussions. What are the challenges? This is what the teachers at in the groups discussed, they came up with. They said finances. This stood out. They kept saying finances. They don't have the money to pay. Technological issues also, lacking skills. They had issues of accessing materials when it came to accessing them online. And then exclusion, particularly teachers with special needs, talked about the materials they need are not available to them. And even when they are availed, they come very late, especially the ones that are supposed to be given by government. Remember, these are public school teachers. Inappropriate materials, they talk about you want to see something or you want to show the students and then something appears that is inappropriate for the children. Restrictions or limited access, they're not able to get as much as they need. And then delays in releasing materials. This one goes to the government, that even when, one teacher said, even when they have to receive books or other materials, when the regular schools have received the materials, especially with the CBC, theirs are coming like a year or so after. So those are the challenges. Now, so there's again a convergence on the challenges as per the teachers' responses. Okay. Let's move. Strategies of overcoming. So we asked them, so what do you do? And so let's move, please. So this figure shows some of the strategies. And so 52% said they just refrained from using the material. If I open and I see something blocking me, let it stay. 22.5% overlooked the obstacle and went ahead to use the material. What are the implications of that? As far as copyright is concerned, 16.3 complied by paying to use the material, and then in significant percentages, that is 1.3, indicated that they used other strategies, including comparison, reading other material, or not applicable. They just said the question was not applicable to them. Let's move. Now, from the focus group strategies, how they overcome, they do good preparation. You prepare your lesson well, you get the materials ready for the lesson. They also said they download and photocopy before using. Just up kidogo. And then the use of digital cameras to take photographs and adaptations. And so when you're talking about photocopying, digital cameras, you know the implications of this. And in this, one of the teachers said that while a colleague had sent the children out to do a photocopy, the child came back with a stranger to the school. And the stranger said he was from the Kenya Copyright, and he had come to arrest the teacher. And so they had to beg the officer not to go away with the teacher. Now, the rest you can fill in for yourself. What happens to the rest of us teachers when such an experience has happened to one of us? We would rather not try it again. But what are the implications to my delivery of my content? Let's move. Conclusions. Now, we concluded that although Kenyan teachers access and use copyright-protected materials, they also create their own teaching materials. Now, we are concluding this on the basis that they say they can improvise, they compare, they share, and so they also generate their own materials using adaptation, modeling, and locally available materials. We also concluded that Copyright Board of Kenya should take advantage to inspire and empower teachers to transition from consumers to producers. Surely teachers, our life is about lesson plan, scheme of work. Then we also, if we are improvising, we could also be creators. And in so doing, instead of us just having to be arrested for using other people's materials, we can also have our materials protected and we earn from them. So our recommendation is, can we empower, can the Kenya Copyright empower the teachers? And then Kenyan teachers face challenges, among others, financial, which is prohibitive costs, digital literacy, exclusion of materials, especially for the special needs category. And then the teachers also end up having delays. Then we need policy reforms to facilitate access to teaching and learning materials. So there's need for reforms. Next. That teachers in Kenya have limited knowledge on copyright. Most of them did not know. They have very limited knowledge. The Copyright Board of Kenya should enhance sensitization and training of teachers to empower them on access and use. Because the only thing that teachers seem to remember is that there's something, and if you do it this way, you'll be arrested. But our suggestion is, we are saying that the teachers can actually be given information in advance. So, creation of awareness. Special needs teachers face unique challenges. That's our conclusion, as far as access and use of teaching materials are concerned. And then we also concluded that policy reforms are needed to create an enabling environment for inclusion and content in readily available, readable formats. Our recommendations, that there is need for more research on relationship between teachers' knowledge on copyright and the decisions they make when accessing and using copyright-protected materials. We also recommend that there's need for analysis of existing copyright laws and exemptions in view of the effects it has on the quality of education in Kenya. And there's need for policy analysis on existing copyright laws and exemptions in Kenya and how they affect special needs teachers and students. Thank you.
Thank you, Dr. Catherine. Let's appreciate how she takes her seat. Wow, that was another very wonderful local perspective of what is actually going on in our country, Kenya. I think that study was commissioned, and she mentioned those are interim results. I think for me, I want to congratulate Dr. Catherine and Charles, getting together Kupet, Nat, and Wasu. From what we see in the news, it must not have been easy. Let's clap for them for that. Yeah, but that's on a light note. I appreciate all the leaders who are here. I've seen the secretary for Kupet, the chair for WASU and the chair for NAT, I think. So another interesting part from those findings, she said 22.5% overlooked challenges and went ahead to use the material. That's typical of Kenyans, don't you think? I expected it to be higher. It means the culture is changing, which is a good thing, because majority refrained from accessing the content. So ladies and gentlemen, to bring us to the last session, rather the last presentation of this session, I'm going to introduce the speaker who is going to talk about the plans and developments by KECOBO. KECOBO is the Kenya Copyright Board. She'll also talk about the copyright limitations and exceptions. This is none other than Mrs. Faith Amatika Omondi, who is the Chief Legal Counsel at KECOBO. And to just introduce her, a small bio. Faith is the Chief Legal Counsel at KECOBO. She holds an LLM jointly from Ankara University and WIPO Academy. Faith has had various professional engagements, including serving as Kenya's focal point in WIPO Committee on Development and Intellectual Property, project on the use of IP in the software sector, consulting for the US Civilian Research and Development Foundation, and as a Cyber Policy Center Fellow at CIPIT, where she published a research paper on the regulation of deepfakes in Kenya. Faith has also contributed on the United Nations Global Digital Compact question of introducing accountability criteria for misleading and discriminating content through the E4E Africa's Digital Future Fellowship early this year. So ladies and gentlemen, please join me to welcome Faith Omondi as she comes to talk about KECOBO plans and developments. Welcome.
Thank you very much, Mr. Manzu. And I want to appreciate the other speakers who have gone before me, particularly the one who was just before me. Her presentation was really touching to me personally, especially when she talked about the teacher who was photocopying a book or something like that, and she was about to be arrested, he or she was about to be arrested. Maybe we'll talk about this with you behind the tent, because I really need to understand what exactly was happening. Yes, I really need to understand what exactly happened. I'm also saddened by the fact that in her presentation, she also mentioned that in the analysis and in the research that she did, very few of the teachers know anything about copyright. And this is really alarming to me as an employee of the Kenya Copyright Board and an employee of this government, as a civil servant who is supposed to be, one of our mandates is to create awareness on copyright throughout the country. So it really saddens me to realize or to understand that very few of our teachers really know anything about copyright. So I'm here to talk about, please let's go to the next slide, or should I do this? Okay, thank you. So the exceptions and limitations of copyright that we have in our law are found majorly in the second schedule of the Copyright Act, and most of what I'm going to talk about was already mentioned by Professor Flynn. So I will not spend so much time. I'm sure I will not spend 20 minutes here. Whatever time has been allocated to me, I will be very brief because most of what I'm going to talk about has already been mentioned by other speakers who have been here before. So the general limitations that we have are found in the second schedule, and you can see that one of them refers to the doing of any of those acts by way of fair dealing for the purposes of scientific research, private use, criticism or review, or the reporting of current events. So you see that the Act provides for the doing of those acts by way of fair dealing. But as has been mentioned by the previous panelists or by the previous speakers, the word fair is not defined, or the word fair dealing is not defined. But as you can see, the way it is couched, it is an exhaustive list. It's an exhaustive list which does not, that means that any use that is not mentioned here does not fall within the exceptions. So that means that if you are doing any act that is not, or you are using the copyright work for any use other than what is mentioned here, then it is not covered by the limitations. You are not, you might be found to be infringing the copyright of the copyright holder in that case. And then there is also the use of those works by way of parody or pastiche or caricature, and then the right to quote. Of course, the right to quote is usually very common in legal, not legal, but any kind of research where you are quoting a previous author and you are quoting them in your research or in your finding, so that is also allowed. And then, of course, the use of a work made for purposes of a judicial proceeding or any report or any such proceeding. So you find that the last bullet, it is kind of open because it's talking about any report or any such proceeding. So you find that it it sounds, to me, it sounds like it's more open. It's not as exclusive as the one in the first bullet. Let's go to the next slide. So the other exceptions that we have are with regard to educational institutions, and this is very important because it is in our education sector that we really need to have these copyright works, made accessible to the learners or to the people who are in need of this knowledge. So you find that the Copyright Act provides that the inclusion in a collection of a literary or musical work of not more than 1 page from the work in question, if the collection is designed for use in a school or any university, and then it goes on and on. So you find that it's also very limiting. It says only not more than 1 page. Well, this is subject to discussion, whether is this too restrictive or is this fair enough for an educational setting. And then the other provisions are there. And of course, the underlying factor here is that whether this information or these materials, these copyright works, are being used in a school or a university. So let's go to the next slide. And then we have the other exceptions with regard to libraries and archives. And we find that it provides that where the reproduction is in the public interest and there is no revenue that is derived therefrom. And then it also goes on to say that the making of not more than 1 copy of a book, including a pamphlet, sheet music, and all that. So it is also restrictive. It is specifying how much can be copied. It's only not more than 1 copy, not more than 1 copy of a book that can be, it's allowed to be reproduced. And then it goes on to say that it has to be under the direction of the person in charge of the public library or the archives for purposes of archiving or preserving where such book is not available in Kenya. Let's go to the next. So when Professor Flynn was here, he talked about fair use and fair dealing briefly, and he said that these are just one and the same thing, so to speak. It's just that one is dealing and one is use, but it's still just use. But there are different perspectives of this. And for Kenya, we always say we are using the fair dealing kind of exceptions. But when we look at the US Copyright Act, because this is where the fair use school of thought, actually, we can say it's derived from. This is where there is the use of words such as including, such as, and that kind of thing. And then there is this 4-step test under the US copyright law, where it talks about the purpose and the character of the use, including whether such use is of a commercial nature or is of a non-profit or educational purpose. And then there's the nature of the copyright work, and then there's the amount and the substantiality of the portion used in relation to the copyrighted work as a whole, and then the effect of the use upon the potential market or the value of the copyright work. So the US has this 4-step test. Let's go to the next slide. And then we have the 3-step test, which is the very common one that we know under the Berne Convention, which is certain special cases, the reproduction does not conflict with the normal exploitation of the work, and it does not unreasonably prejudice the legitimate interest of the author. So this is now what we are looking at as Kenya. As I mentioned earlier, we are reviewing or overhauling the Copyright Act in totality. And we are even now proposing to have a definition of what fair dealing is. And what we are looking at,
or the proposals that we have. This may not be the final one, but this is just like, I'm giving you a sneak peek of what we are doing. What we are proposing is to have the definition of fair dealing under this, like it encompasses the provisions in the Berne Convention under this Article 9.2, where we are talking about the use has to be satisfy this three-step test. And then it goes on to say that it shall include, the list of the works specified, or the uses specified shall not be exhaustive as it is right now, but it shall include words like including, such as, and that kind of thing. So the question is, are we then just saying that we are going the fair use way, but we are still saying that we are doing fair dealing? I really don't know the decision, or at the end of the day, what we want is the people should be, or the users, especially the vulnerable groups, the ones who are not able to access, especially reading materials. What are they going to base on if they access these materials without being considered to be infringing the law? Let's go to the next slide. So this was just a comparison. And when you look at the Berne Convention and the US Copyright Act, you'll find that the tests in the Berne Convention and the tests in the US Copyright Act are more or less the same. But then it's just that under the US Copyright Act, there is the other fourth test, which is the nature of the copyright work, which you do not necessarily find it specifically in the Berne Convention. Let's go to the next slide. So we have other jurisdictions. This is now in relation to the text and data mining uses of copyright works, whereby in the UK, they have specifically introduced a clause or a section in their act under the new section 29A, where it talks about exceptions for making copies for text and data mining analysis for non-commercial research. So this is what it provides. I'm sure this can be available to you to read, and the link is also provided there for this particular section. So we find that in the UK, they have an express provision for this, but in Kenya, we do not have, although there are some major changes that we are proposing. As I said, we are including a definition of fair dealing. We are also proposing to have a definition of research, as opposed to just scientific research. We are proposing to have a definition of just the word research, which is going to be, more inclusive, as opposed to the way it is right now, where that definition is not provided. And then we are also proposing to have, as I said, the use of phrases such as, and including. And then I've already talked about fair dealing, what we are proposing to have. We are going to adopt the three-step test. And then on the issue of text and data mining, we're also including a provision on computational analysis to be one of the exceptions. And then we are also, on the issue of contract override clauses, that one, I will be honest, we have not considered it, but now that it's been mentioned here, I'm sure this is something that can be talked about. Next slide, please. So, yes, so this is just a continuation of the previous one, so let's just go to the next one. So the question that we are asking is, and this is what I said at the beginning, which way do we want to go? What are we looking at? Whose interests are we looking at this point? And this reminds me of a time when I was in the UK attending a certain conference. It was organized by the British Copyright Council, and there was one professor who mentioned something that he called, he called ethical hacking, or not ethical hacking, but ethical piracy. Ethical piracy. And you might think that is weird and strange, but when you look at the situation in Kenya right now, with the introduction of CBC and the grade 7 classes being the pioneer classes in this new educational curriculum that we have in Kenya, and we heard of reports at the beginning of the year where children had no books in school completely. They went to school and they had one teacher and they had no books because they are not accessible. The books are just not available to them because they're in public schools and something happened and the books are not available. So what if a book is photocopied, 100 copies, and they're all given to read? Ethical piracy. Think about that. Thank you.
Another round of applause for Faith. So, ladies and gentlemen, we've come to the end of the session, which I was asked to moderate, the second session. And I'd just like to appreciate the 5 distinguished speakers who have actually given us very insightful overviews of from the global perspective to the local perspective of R2R and A2K. We started off with Sean, who gave us the global perspective, and we realized that actually Kenya has adopted the open research exception and is considered a green country in terms of fair dealing. And then Jonathan came and gave us new global findings, and we realized there's a gap. Kenya has not adopted the, trying to remember, it was the targeted contract override prevention clauses. And the ball was thrown to Kekobo and all the other players in the Kenyan market to see how we can actually move to that. And after that, we went to now the local perspective, where we got research findings from our colleagues at Strathmore University, who did research on the status of text and data mining. And we saw some of the gaps that have been identified and what needs to be done. And then we got another very insightful presentation from Dr. Catherine on a commissioned study, giving us perspectives from the classroom. And then to wrap it up, we had Faith, who actually told us what Kekobo plans to do, and we hope that we can be able to support them to be able to bridge this gap. So I have been your moderator, Arnold Mwanzu, and I look forward to the next session. Thank you very much.
Are you awake or sleeping? The other clap you just did was a bit weak, so another round of applause to our speakers who did an amazing job. Thank you so much. So just before we go off to lunch, which I'm pretty sure most of you are hungry now, I'll just take a few people with key takeaways and key highlights from the session that we just had. Any takers? Also, our online audience, please feel free to put in your questions, comments in the chat, and all the questions that you may have, also for those who are here, will be answered during the afternoon session. So any takers for key highlights from the session we've just had? I can also do the picking thing once again because it works. So we'll do this again. Front, center, back. Front. Any takers? Joshua? And so just to prepare the next people, center, we are doing the lady who's seated in the middle with a maroon Polnex sweater with a blazer, who's looking at me now. Key takeaways. And back, let's see. The lady with spectacles at the back, Robbie, yes. So, Joshua.
All right, my takeaway is that more needs to be done in the education sector to educate about copyright. Yeah.
Thank you. Santa, you don't get a pass, unfortunately. Just a key highlight. It doesn't need to be a lot. You can even just say hi to us. That works. Please say your name, where you're from, and yeah.
Well, good afternoon, everyone. I think for me, what stands out is the communication gap between, core ground, like in the grassroots, in terms of copyright, and the conversations we're having here. I'm just wondering, how can we bridge that gap in terms of communication?
Lovely. And to think you were going to pass. Thank you so much. Those are actually very key points, which I think will form a better part of the discussion for the afternoon session. So the back, Robbie.
Hello, everyone. My name is Robbie Muita, a research intern at CIPIT. And I think my key takeaway from this session has been, first of all, I was surprised when the last speaker, Faith, expressed shock at the fact that teachers didn't know much about the Copyright Act. So I think I look forward to seeing what Kekobo will do about that going forward. Although I also have to congratulate Kekobo about what they've been doing to improve knowledge of the Copyright Act in Kenya.
Sorry.
because I see that they have a lot of content online to try and reach as wide an audience as possible. So Faith, I look forward to seeing what your team will do going forward.
Thank you so much for those highlights and comments, which I'm sure will again form a better part of this discussion for the afternoon session. So lunch talk. You will be having your lunch at Watamu Cafe, where you had your morning tea as well as your tea break. And just slight housekeeping announcement. For those of you who walked in with bottles, the glass bottles, please make sure you walk out with them and you can just dispose them on the crates that are outside. Also, if there's a bit of littering on your end or you have a little bit of paper from your end, there's a dustbin right at the back. So as you walk out, just dispose of them there. And especially for the bottles, so that when you're coming back in or you're going out, you're not kicking any of them. So thank you so much for our online audience. Thank you so much for your presence. We hope we'll be hearing more of you during the afternoon session, and lunch is served. And you come back at exactly 2:15. Okay. Also, as you walk out, kindly ensure that you take moments, and you feel free to take pictures outside, and so there'll be a group photo that will be taken outside as well. Okay. Thank you. In terms of safety of your items, which